Hello, today is Monday, August 2nd, 2021. I'm Joe Schmidt from TC2, and this is Staying Connected. In May of 2018, the European Union adopted the General Data Protection Regulation, finally known as GDPR. The intent of GDPR is to provide sweeping data protections for consumers. When GDPR was enacted, we at LB3 and TC2 surmised that it was only a matter of time before this type of regulation would make its way to the U.S. Well, it did, first landing in California as the California Consumer Data Protection Act, or CCPA. Similar laws are now rolling out in Virginia and Colorado, and soon lots of other states. What does it all mean for enterprise buyers of technology? Well, let's find out. I'm joined by two of my LB3 colleagues today, Deb Boehling, a partner at LB3, and Laura McDonald, who is also a partner at LB3. Deb and Laura have so much to share that we're going to make this a two-part series, and this obviously is part one. Hey guys, thanks for joining me today. So, Deb, what does this data protection regulatory wave mean?
Hi, Joe. First of all, it's great to be back on Staying Connected. We reported last year on the new California Consumer Privacy Act and foresaw a trend of state legislation in this area. Sure enough, in early March, Governor Northam of Virginia signed into law the Virginia Consumer Data Protection Act, the VCDPA, and in July, Governor Polis of Colorado signed the Colorado Privacy Act, the CPA. Each state's law protects consumers residing in that state, more closely aligns with GDPR, and fills in gaps left by California's privacy law. The Virginia Act, which is more business-friendly, takes effect January 1st, 2023, while the Colorado Act, a middle ground, takes effect July 1st, 2023. Virginia and Colorado are the second and third states, after California, to enact comprehensive privacy legislation, though they are likely to be far from the last. Laura and I are going to give you a high-level summary of the provisions of these new laws and what they mean for businesses doing business in those states. We'll also talk about how they affect businesses' agreements with their IT and telecom providers.
And let me point out that this discussion is going to be high level, but you and Laura, you have a ton of detailed information available on LB3's website.
Yes, that's right.
All right. So, Deb, what states are in line after California, Virginia, and Colorado?
Well, we don't know which will actually be enacted, but right now legislation has been under consideration in Florida, Illinois, Massachusetts, New Jersey, New York, North Carolina, and a bunch of other states. So you'll likely hear from us again soon.
So who's affected by those new Virginia and Colorado laws?
If your company does substantial business in Virginia and Colorado, these laws likely apply to you, and we'll assume they do. The technicalities of whether they apply can be found on our website.
Okay, so if one or both acts apply to a company, what are the company's obligations?
That depends on whether you are a controller or a processor of data. You control personal data and are a controller if you determine the purpose and means of processing the personal data, alone or jointly with someone else. You process personal data and are a processor if you perform any operations on the data, including collecting, using, storing, disclosing, analyzing, deleting, or modifying the personal data. This covers just about anything that can be done with data. So you can be a controller, processor, or both, depending on what you do with the personal data.
All right, let me bring Laura in here. Laura, what exactly are the obligations of a controller of data?
Thanks, Joe. And again, it's great to be here, particularly talking about such a compelling topic in two states that I call home, Colorado and Virginia. But to your question, data controller obligations fall into two categories. One is to respond to consumer requests, to exercise certain rights that they're granted under these two acts. The other includes a set of requirements affecting your collection, handling, or disclosure of personal data. And you'll see an article on the website that Deb and I wrote that gives you a little bit more detail.
It sounds like I better let the website folks know to expect a lot of traffic after this podcast. Okay, so Laura, how about if you explain what a company has to do to respond to a consumer request?
Sure, happy to. In each state, as we indicated, customers have certain rights. and you have certain obligations as a business to comply with those rights or requests. So, for example, you have to confirm whether or not the controller is processing the customer's personal data and allow the customer to have access to that personal data that you're collecting. If the customer identifies an error in that, you have to correct the inaccuracies of that data. In certain circumstances, you have to delete the customer's personal data, and the customers have a right to get that data, so you have to be able to provide them a copy of it. You also have to allow them to opt out of processing their personal data if it's for purposes of targeted advertising, the sale of the personal data, or profiling the customer. Now, just a reminder, each of these states phrases the rights and responsibilities slightly differently. So you really need to pay attention to the exact wording of the act to determine exactly how you have to comply. And devil is always in the details. So some of these rights are subject to exceptions. And again, take a look at our website. We can give you a little bit more information there.
And Deb, what are the general controller requirements?
Well, the controller must also comply with ongoing duties. They need to limit the collection of personal data to what is reasonably necessary to meet the purposes for which it is processed, as disclosed to the consumer. This is referred to generally as the minimization and transparency obligation. Controllers are prohibited from processing data for purposes not reasonably necessary to or compatible with the purposes that you've disclosed to the customer. You need to establish and maintain reasonable administrative, technical, and physical security practices. And don't process personal data in violation of federal or state anti-discrimination laws. Don't discriminate against your consumers for exercising their rights under the Act, although you may offer different incentives for not exercising your rights. You also need to obtain the express consent of the consumer for the processing of certain sensitive data. And as Laura mentioned, the devil is in the details, so you need to look at the different acts for the definition of sensitive data and the specific obligations.
So is there anything else?
Sure, yes, of course. You must provide a clear, meaningful, and accessible privacy notice that includes the categories of personal data you process, the purposes for which the processing is done, the procedures for exercising the consumer rights that Laura mentioned earlier, the categories of personal data you share with third parties, and the categories of third parties with whom you share personal data. If you sell personal data or process it for targeted advertising, you must clearly and conspicuously disclose that you do so. And you must also disclose how the consumer can opt out. You must conduct and document periodic data protection assessments, and those assessments must meet specified requirements. Finally, you must follow certain requirements with regard to de-identified data. And when we talk about specified or certain requirements, again, those differ between the states.
All right. So Laura, I'm not the lawyer, but that seems like a lot. So there must be some contract requirements for enterprises in all of this.
Joe, you're absolutely correct. There are many contractual obligations that you need to be thinking about. But I have to warn you, it's pretty detailed.
All right. Well, in that case, let's end this part 1 and pick up with enterprise contracting requirements in part 2. Now, if you'd like to learn more about these Consumer Data Protection Acts, please contact Deb or Laura by giving them a call or just send them an email. You can also contact me or any of the LB3 or TC2 professionals that you work with, and we'll connect you in with both Deb and Laura. Now, you can also access a lot of great data, as they've mentioned, on this topic on LB3's website. And then, as always, if you want to stay current on the ICT industry goings on, please subscribe to these podcasts. You can take a spin around our websites or just follow us on LinkedIn.